All right, let's talk about transformative use and parody, what constitutes a parody. But first, I want to say there's two links underneath these lectures, along with the links regarding fair use in online video. There are two links to the U.S. Copyright Office. One is to a video, it's about 3.5 minutes long, that it generally explains fair use and the factors that we had just gone over. And there's also a written description of the 4 factors. That's the other link for further information or further clarification on the factors relative to fair use. So, transformative. This test is used under factor 1, purpose and character of the use, element 1, factor 1. And transformative use is defined when when someone takes a portion of a copyrighted work and uses it for another purpose, i.e. transforms it. That could be another message. You have to have more than merely just copying the original. It has to be changed in some way. And the test for that is whether or not a reasonable observer would find the work transformative. It's adding something to the copyrighted work for it to be considered a transformative use for purposes of a fair use argument. So remember, you have to look at all the factors, not just one, and transformative falls under the first factor. What about something that's removed from a work? Is that transformative? No, it has to add something. An example, there was a case, Clearflix was in business of buying copies of films released on DVD. Then they would edit them. They would take out what it regarded as offensive content and then sold those cleaned versions. They were sold by the motion pictures industry. Clearflix argued that it was a transformative use. I'm not harming the market. I'm exploiting a new market. and he said, and I bought these videos. This is for sale doctrine. I can resell them. You see any problem with that argument? The court said, number 1, not transformative when you're deleting materials. It's only when it's adding to the work. But also, you're affecting the potential derivative that might be the derivative right that might be available to the original owner. You're altering the original work. It's a derivative. And movie companies can technically do that if they want. If they wanted to remove what they thought was offensive content, then they could do that and sell those. That's foreseeable that would be a derivative work from what the movie companies do. And record companies do this already. The sound recording folks, there's songs out there. They have the clean versions for radio play, and then they have, the regular versions. So you have to actually add something in order for it to be transformative. And we'll explore this test in the next video with the examples, the example cases. We'll go through the 4 factors and put together the transformative test. And the first case we're going to explore it on is going to be to parody. So, what is a parody? A parody is a work that ridicules another work by imitating it, often in a humorous manner. In itself, a parody is a derivative work and an infringement of the copyrighted work. Right? It's a derivative spin-off, right, of a work. So, in order to avoid liability, the parodist must establish a fair use defense. Whether a parody is a fair use requires an analysis using the fair use factors. Parodies are a form of criticism or commentary. Remember the likely categories of fair use that we start off with? You start looking at the work first under the purpose of the work. Parodies are a form of criticism or commentary on another work. However, a parody is unlikely to be a market substitute for the copyrighted work since it has transformative purpose. Consumers are unlikely to purchase the parody rather than the original work because it does not serve the same purpose as the original. Furthermore, because a parody is critical of the original work, most copyright owners do not ordinarily create or license others to create parodies of their own works. So, fair use is their only option if they want to use a copyrighted work. Now, the seminal case on this parody is Campbell versus Acuff Rose Music. And to kind of put this case into context, I have linked under the additional materials in Moodle, and I suggest you probably want to give them a listen first so you can put it into context as you hear about this case. Two songs. One is Two Live Crews. Two Live Crew uses the Roy Orbison song Pretty Woman. Two Live Crew creates a song, it's called Pretty Woman, and they use Roy Orbison's song in order to create their new work. So the links are of the two songs, so give them a listen. And this is a Supreme Court case that basically sets the standard for a parody using the four-factor test. So the full case is in the book. If you want to read the full case, I am just going to go over the test analysis. So in 1964, just to give you some background, in 1964, Roy Orbison and William Dees wrote a rock ballad called Oh Pretty Woman, which was subsequently recorded by Roy Orbison and copyrighted by the music firm Acuff Rose Music. When Oh Pretty Woman was released, it quickly sold more singles than any other record in rock and roll history. In 1989, Luther Campbell, founder of a popular rap music group, Two Live Crew, published an album called As Clean as They Wanna Be. And included on that album was a version of Orbison and Dee's song entitled Pretty Woman. Before recording Pretty Woman, Two Live Crew had contacted Acuff Rose to obtain permission to use the copyrighted work, but they refused to license the copyright. So nevertheless, they recorded it and used the song, sold about 250,000 copies on its release. The group later stated that their song was intended, quote unquote, through comical lyrics to be a satire of the original work. And so the music company brought the action and sued Two Live Crew. It made its way up through the lower courts and landed before the Supreme Court. And the Supreme Court ruled that this use, hopefully if you've listened to the songs already, the use were fair use through the use of a parody. So let's go through the four-factor test here. Factor 1, the purpose and character of the use, including whether such use is a commercial nature or is a non-profit educational purposes. And you first have to turn to, according to the court, you turn to those initial factors of criticism, comment, news reporting, etc., for the essential purpose of looking into this work, whether the new work merely supersedes the objects of the original creation or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, and message. It asks, in other words, whether and to what extent the new work is transformative. So we're looking at it under the microscope of whether it fits one of those elements or one of those elements: criticism, comment, news reporting, educational teaching, and if there's been some transformation. So the court said that, when you have a parody, there's obviously a claim to transformative value. Okay, it's funny. In this case, it's a humorous form of criticism that can provide a social benefit by shedding light on an earlier work and in the process creating a new one. So a parody, like other comment and criticism, may claim fair use. For the purposes of copyright law, the nub of definitions and the heart of the parodist's claim to quote from existing material is the use of some elements of a prior author's composition to create a new one that at least in part comments on the other's work. So we have to have criticism and comment. If, on the contrary, the commentary has no critical bearing on the substance or style of the original composition, which the alleged infringer merely uses to get attention or to avoid coming up with their fresh own work, that is going to not count. So you need some sort of criticism or commentary. The parody needs to mimic an original to make its point, and so has to have some claim to the use of the work. Whereas satire can stand out on its own 2 feet, and so requires justification for the very act of borrowing. So this court says, so where there is criticism and commenting in a parody, that's step 1. Step 2 is the transformation. So the court then looks to actually the content and the lyrics to determine whether or not there's a criticism. They do find it, quote unquote, they say to some degree, as commenting of the original or the criticism. And basically it's the lines or the concept of the romantic musings of a man whose fantasy comes true with degrading taunts and a demand for sex and a sigh of relief from paternal responsibility. The later words can be taken, according to the court, the later words can be taken as a comment on the naivety of the original of an earlier day, as a rejection of its sentiment that ignores the ugliness of street life and the debasement that it signifies. It is this joinder of reference and ridicule that marks off the author's choice of parody from the other types of comment and criticism that traditionally have had a claim to fair use. So the court finds that this parody has some criticism to the underlying work. By the song itself, there's some transformation in listening to it. They do change some of the lyric words. We'll draw that out in a little bit. The second factor is the nature of the copyrighted work. And they don't spend a lot of time here because they just say, well, it's a parody. Since it's a parody, it's almost invariable that they have to copy publicly known or expressive works. So they kind of glide past that as a chalk up for the Roy Orbison crew. Yeah, your work is creative expression. Yeah, it has to be copied. That's the point of the parody. And then they head right on into factor 3 and ask whether the amount and substantiality of the portion used in relation to the copyrighted work as a whole are reasonable in relation to the purpose of the copying. And this factor calls for thought not only about the quantity of the materials used, but about their quality and importance too, because parodies are a little different. Parodies are humorous. They need to do that in the event to get its comments across. So it has to decide the court has to decide whether or not they use the entire work or use the heart of the work. It is true, they point out, that Two Live Crew copied the characteristic opening bass riff, right? That's what we all know. When you hear that, you can relate it to the song. The opening bass riff of the original, and true that the words of the first line copy the Orbison lyrics. But if quotation of the opening riff and the first line may be said to go to the heart of the original, the heart is also what most readily conjures up the song for the parody. That's what you need, and it is the heart at which parody takes aim at. So you need it. Copying does not become excessive in relation to the parody purpose merely because the portion taken was the original's heart. Now, mind you, we're talking about the parody, not any other type of work. This is a case-by-case analysis. So in parody, as in news reporting, context is everything. And the question of fairness asks what else the parodist did besides go to the heart of the original. Well, aside from those things, they've added their own entire lyrics. They added some other, overlay of music and scratching noises and so forth. So they say this is not the case then, where a substantial portion of the parody itself is composed of a verbatim copying of the original. Suffice it to say here that, as to the lyrics, no more was taken than necessary. So it met factor 3. The fourth factor, the use, this is the effect, the use upon the potential market or the value of the copyrighted work. Generally, when you have a parody, according to the court, you have two works. You have two different original markets, one that's going to be for the parody and one that's going to be for the original. Does the parody affect the original market? In this case, with the information that was before the court, they said no, there appears to be two separate markets. But more importantly, what they wanted to add and discuss was, but is there a separate market for Oh Pretty Woman, the original, i.e. a derivative? And in addressing that issue, neither party nor the court had any evidence before it available that would suggest there was any effect on a potential derivative market for Roy Orbison to create basically a non-parody rap version of Oh Pretty Woman. And it further went on to say that was that really foreseeable that Roy Orbison would actually do that or create that? And the answer was no. So that's how we get to this idea of a parody. But don't think that a parody is just because it's funny and it takes something from an original that it's going to be a fair use. Oh, it's funny. It's going to be like Weird Al. Weird Al may not necessarily fall under the parody category unless, one, he's doing some sort of criticism, commentary, which is general for a parody. You're not going to get to the research and education and teaching and news reporting. It's going to be critique or commentary. So that's like one of the first components they're going to look at, court's going to look at, before heading down and reviewing the 4-factor test. Weird Al is not going to want to go to court every single time he wants to use somebody's song and hope that he wins a fair use claim, because that's what it comes down to. If somebody thinks you're infringing and you didn't get permission, then you're going to find that the person's going to be in court and having to argue that it was a fair use. So Weird Al always gets permission, and he's been denied lots of different songs he wanted to parody. But nonetheless, so parody isn't always so clear-cut, and you have to explore the factors. So just to kind of recap, you need some sort of comment or criticism on your parody. There has to be some sort of transformation, new message, new purpose. You have to consider the market. We already know that there's copying that's involved of an expression, of a creative expression work. So the second factor isn't going to carry a lot of weight for a fair use argument. Number 3, how much of the work are you using? In a parody, if you go to the heart of it, it's generally accepted because that's what you need to create your work. The heart takes aim at the heart of the work, but otherwise creates a distinctive work. But that also doesn't work with a regular fair use claim either if you're using the heart of a work and you don't have a parody. And whether or not there's some sort of derivative related. And we're going to talk about one of these cases relative to derivative in the next video. So now we're going to put this all together. We're going to look at another parody or two I think. Definitely one. There's a bunch of cases. We're going to look at this transformative test. We're going to see how courts have interpreted it and how you're going to see, depending on where you are, there might be a different result. So make sure that you have watched listened to their videos, but listen to the Two Live Crew and the Roy Orbison song. And at this point, if you haven't already, review the U.S. Copyright Office 3-minute video on fair use and review the 4-factor test. Then come back to the next video where we're going to go through a bunch of cases. And then finally, you should be looking at the online creating videos online.